Hello everyone, my name is Ritesh and today we'll discuss the current affairs topic, right? And today's topic is financial resolution and deposit insurance bill, right? So in this video we'll talk about this whole bill and what are the main provisions of this bill and what are the main areas of concern over this bill, right? So we'll discuss first thing, we'll discuss why this was in news, right? Then we'll discuss the main provisions of this bill, how and what are the provisions that this bill covers over this area, right? And then we'll discuss the significance of legislative backing of this bill, of anything of basically we'll discuss the significance of the legislative backing, right? And that's it about this whole bill. So let us start with this topic. So first, let us discuss this, why this bill was in news and why this thing you have read in your newspaper or in your editorials, right? So recently, Finance Ministry has sought views of the Reserve Bank of India on drafting a modified version of Financial Resolution and Deposit Insurance Bill in order to deal with insolvency of firms in the financial sector, right? So, the Finance Ministry actually has taken views from RBI, Reserve Bank of India, and says that on drafting a model or modified version of this bill, Financial Resolution and Deposit Insurance Bill. Why? Because they want to deal with the insolvency of firms in the financial sector, right? So, for the main area concern of government is to cover is to deal with the insolvency of firms in the financial sector. Right now, in 2018 also the government had withdrawn this bill amid concern over the security of bank deposits. So the main area of concern in 2018 was the security of bank deposits, and that is why the government had withdrawn in this bill in 2018, right? So this you have to remember, what are the area of concern, because why the government had withdrawn this bill in 2018, right? So the security of bank deposit is the area of concern, that is why they have withdrawn this kind of bill in 2018, right? Then the FRDI bill, which is basically Financial Resolution and Deposit Insurance Bill 2017, was meant to address the issue of insolvency of firms in the financial sector, right? So this bill was actually meant to address the issue of insolvency of firms, right? And especially related to the financial sector, right? Now, let's discuss the provisions of this bill and what are the key provisions that are being mentioned in this act, in this main bill, right? So, first thing is, if a bank, NBFC or an insurance company, a pension fund or a mutual fund run by an asset management company fails, a quick solution is available to either sell that firm, merge it with another firm or close it down with the least disruption to the system and other stakeholders. Now, this bill talks about if a bank, NBFC, insurance company, pension fund or a mutual fund anything run by an asset management company fails. If these things fails, a quick solution is there, right? A quick solution is available there for these entities, right? To either sell that firm, right? Or merge it with another one, or to close it completely down. Right, and these things are available to them with the least disruption in their system and the least disruption to the other stakeholders, right? So this bill aims to decrease the disruption in the sector actually, right? So if you have if you want a solution, so if a bank or an NBFC or an insurance company or anything attached to this wants to quickly solve this problem, so this bill actually enhance the process and give a simple and easy solution to either merge it with another company or completely close it down or either sell that particular firm or that company, right? And these things will go hand in hand with the least disruption in their system, or they will least disruption to the stakeholders involved in that system, right? Second is, it is aimed at it aimed to limit the fallout of the failure of institutions like banks, insurance companies, non-banking financial, NBFC like, right, pension funds and stock exchanges. So the bill was withdrawn due to concerns among the public over the safety of deposit despite assurances by the central government. Now this bill was aimed at to limit the fallout of the failure of institutions, right? So there are many institutions that that with time they fall out, right? So it will ensure them, right? And why this bill was withdrawn was the issue of security of security, safety of deposit assurances, right? So the bill, the main reason behind this bill, withdrawn of this bill, was because due to the concerns among the public over safety of deposit, despite assurances by the central government. Central government had assured these deposits, right? But still the bill was withdrawn because there were some safety concerns related to that issue, right? Then the key point of criticism was the so-called bail-in clause in the bill. Now, what is the bail-in clause in the bill, right? So it is, in case of insolvency in a bank, the depositors will have to bear a part of the cost of resolution by a corresponding reduction in their claims, right? So this was the reason also, and that is why this bill is being criticized, that if they want to, so if they want to solve this whole process, and if they want to like completely close it down, or they want to merge that firm or anything, they want to quickly get a solution over this. So the depositors have to bear a part of the cost of this resolution process, right? So that is why this bill was being criticized, that why the depositors money has been hampered, why their claim has been reduced because of the money involved in the resolution process, right? The main idea of criticism is that the resolution process wants depositors to engage their money in the resolution process. That's it. So let's talk about this new bill now, right? Now the bill will provide for establishing a resolution authority which would have powers to undertake prompt resolution for banks, insurance companies, and systematically. So let's discuss this new bill. So this new bill will provide for establishing a resolution authority which would have powers to undertake prompt resolution for banks, insurance companies, and these financial firms. So this new bill actually established a new kind of authority, resolution authority, like, and which will actually have power to undertake action, right, for banks, insurance companies, and these financial firms, right? Now the legislation will also provide for an insurance up to rupees 5 lakh for bank depositors which already has a legal backing. So these two are the main provisions of this new bill, and the main idea is that they are establishing a resolution authority which will take actions in case of banks, insurance companies, and these financial firms, right? Now let us discuss the significance of this legislative backing, right? So even as the RBI has came out with the prompt corrective action framework for NBFC. So this PCA framework is for non-banking financial companies, right? So a need is being felt for a legislative backing for the entire financial sector. So basically RBI has come out with a PCA framework for only NBFCs, right? Non-banking financial companies. So if there is a framework for NBFCs, so there's a need that is being felt that we want also some kind of legislative banking, not just for NBFCs but the whole financial sector, right? So the current resolution design is especially inappropriate for private sector financial firms in the light of significant expansion and many of these acquiring systematically important status in India. Now the reason is that first thing is that our financial sector is actually growing very well, right? And because the government is also focusing more on these sectors right now, so we need actually a legislative banking, and not just a legislative backing but a good legislative banking which will allow them to grow a little more, right? So that is why legislative backing of these sectors, right, is very important, because there are so much money involved in these sectors, right? And if there are so much money, that means there must be corruption in these sectors too. So so that is why we need a legislative backing in these sectors, right? Now, the provision of a single agency for resolution of financial firms is in line with the recommendations made by the Financial Sector Legislative Reforms Commission 2011, headed by Justice B.N. Sri Krishna. Now, you have to remember this name, Justice B.N. Sri Krishna Committee, right? And these reforms are in line with this committee report, right? So that is why it is very important. Now, even the Insolvency and Bankruptcy Code 2021 along with this bill would have streamlined the procedure for winding up or revival of an ailing financial sector firm, right? So not just this bill but also the Insolvency and Bankruptcy Code 2021, and these two things will streamline the whole process, the whole procedure for winding up or revival of a ailing financial sector firm, right? So if a financial sector firm want to resolve a process, want a resolution process, this two legal backing will be there, and they will resolve the whole process in a very easy manner or in a very phased manner, so that all the stakeholders that are getting involved in these sectors won't get much hampered, right? So that was all about this bill. So just remember the keywords over this whole bill, that what are the committees involved in the whole process, what are the reasons that government had withdrawn this kind of bill, right? And then what are the issues with regarding this bill, right? And then the new bill came into place, and what are the authorities that are being concerned with this bill, right? So these are the main things under this topic, right? So thank you so much for this topic.